Dear all, today we are going to see the company law and corporate governance, which is a course in the first year, first semester. In it, we are going to discuss about the topic of features of a company. There are so many definitions of a company by various legal experts. However, Section 2, subsection 20 of the Companies Act 2013 defines the term company as follows. A company means a company incorporated under this act or under any other previous company law. Now, to the characteristics of a company: voluntary association, 2. Incorporation, 3. Artificial person, 4. Separate entity, 5. Perpetual existence, 6. Common seal, 7. Transferability of shares, limited liability. Now, for the voluntary association, a company is normally a voluntary association of two or more persons who have joined together for some sort of a common purpose. Now, the separate legal entity. It is one of the most distinctive features of a company as compared to other organizations. That is, it is having the unique character of being a separate legal entity rather than the other things. However, when we want to register a company, we can give a legal personality with similar rights and powers, just like a human being. The existence of a company is distinct and separate from that of its members. It can own property, bank accounts, raise loans, incur liabilities, and enter into contracts. Also, it has a distinct personality which is different from those who compose it. A member can also contract with the company and acquire a right against it or incur a liability to it. However, for any debts, the creditors can sue the company, but the members cannot. A company can own, enjoy, and dispose a property at its own name. While the shareholders contribute to the capital assets, the company is the rightful owner of such assets and capital. Further, the shareholders are not private or joint holders of the company's property. Next, the perpetual succession. Another important feature of this is of a company is that a company can continue to carry on the business, notwithstanding the death or change of its members until it is bound up on the grounds specified by the Companies Act. Further, the shares of the company change hands infinitely, but that does not affect the existence of the company. In simple words, since the company is an artificial person which is brought into existence by the law, it can be ended by the law alone, and so it remains unaffected by the death or insolvency of its members who are the founders of the company. Third, limited liability. One of the important features of a company is the limited liability of members. The liability of a member depends upon the type of the company. In the case of a limited liability, the debts of the company in totality do not become the debts of its shareholders. In such a case, the liability of its members is limited to the extent of the nominal value of shares held by them. The shareholders cannot be asked to pay more than the unpaid value of their shares. In case of a company limited by guarantee, members are liable only to the extent of the amount guaranteed by them. For this liability arises only when the company goes into liquidation. Finally, if it is an unlimited company, then the liability of the members is unlimited. But such instances are very, very rare. Next, the artificial legal person. Artificial because its creation is by a process rather than a natural birth. Legal because it is created by law. Person having similar rights to a human being. Further, a company can own a property, bank account, and do everything that a natural person can do except go to jail, marriage, take an oath, or practice a learned profession. Hence, it is a legal person in its own sense. Since the company is an artificial person, it needs humans to function. These humans are directors who can authenticate the company's act either on their own or through the common seal of the company. The common seal. While a company is an artificial person works through the agency of the human beings, it has an official signature. This official signature is affixed by the officers and employees of the company on all its documents. This official signature is called the common seal. However, this Companies Amendment Act 2015 has made the common seal as an option. Section 9 of the Act does not have the phrase "and a common seal" in it. This provides an alternative mode of authorization for companies who do not wish to have a common seal. According to this amendment, if a company does not have a common seal, then the authorization shall be done by two directors or one director and the company secretary if the company has appointed a company secretary. Then the transferability of the shares. Or if in the case of a public limited company, the shares are freely transferable, whereas in a private limited company, the shares are not freely transferable as the case may be. Thank you all for the patience.